Good afternoon. I call this meeting of the Health, Finance, and Policy Committee to order. We have a quorum present. And first, I would just like to provide some brief reminders about our committee rules. Signs are not permitted in the committee room. Verbal outbursts, shouting, applause, or other disruptions are not allowed. Sitting or standing in the aisles is not permitted. And the State Patrol and House Security staff are present to ensure everyone's safety. If you leave the committee room, please hang on to your tickets to re-enter. We have a full agenda today, so we will be limiting testimony to 2 minutes per person so that everyone has a chance to speak. First is approval of the minutes. Vice Chair Ryer, have you had a chance to review the minutes for the February 18th meeting?
Mr. Chair, I have, and I move approval of the minutes from February 18th, 2026.
Vice Chair Ryer moves approval of minutes for February 18th. Any discussion? Hearing none. Those in favor say aye.
Aye.
Those opposed? The minutes are adopted. I think I failed to mention the date today. We'll put that in here for the record as well. It's Monday, February 23rd, 2026. So our first bill, and our testifier is already ensconced where he needs to be. House File 362. This first bill of the day by Representative Pinto. Welcome, Representative Pinto, to the committee. And I will move the House File 362 be recommended to be re-referred to the Judiciary, Finance, and Civil Law Committee. Representative Pinto, I understand you have a DE1 amendment. Would you like to explain the amendment, please?
Thank you, Mr. Chair, and thanks, members. The amendment just makes some technical changes to the bill, adds and changes, removes some words to be consistent with how MDH operates, updates some effective dates and timelines, and that sort of thing. I will note that there was one other additional cleanup that's in the form of an A2 amendment. I'm trying to recall exactly how to, sort of what order to do a secondary amendment.
We will do the DE1 first.
Okay.
Any discussion to the DE1? Seeing none, all those in favor say aye.
Aye.
Those opposed? The motion prevails and the amendment is adopted. So then to the A2, Representative Pinto, a technical amendment.
Yeah, Mr. Chair, I think staff noticed that at line 4.9, there's a head note that says that Section 4 of the bill contains material on data practices. It actually does not. It merely contains limitations on practice, and so the A2 amendment just would strike the superfluous phrase data practices from the head note.
I will move adoption of the A2. Any discussion? All those in favor, say aye.
Aye.
Aye. Those opposed? Motion prevails and the amendment is adopted. Representative Pinto, to your bill as amended.
Thank you so much, Mr. Chair, and thank you, members. Members, currently Minnesota regulates massage therapy and the other practices that are in the bill through an inconsistent patchwork of local regulations, so about 100 plus different local ordinances that, as I say, are patchwork, some areas of the state regulations, some not, et cetera. What the bill does, it replaces that with a uniform education-aligned and statewide licensure system with a number of benefits that I hope that you'll hear from the testifiers. It's my view, and those of them as well, this would improve public safety, support small businesses, and reflect professional standards that are already in place across our state. The testifiers, I think, are going to address a number of issues. I'm going to bring up something that is particular to my own interest in the bill, and I bring this up not to overstate it regarding other aspects of the profession, but my own interest in this, and the reason I've carried this bill for a number of years in a row now, relates to my work as a prosecutor outside the legislature. Folks may be aware that I served for several years as the director of statewide training and protocol development for the Safe Harbor system in Minnesota, which addresses exploitation and trafficking of young people. In the course of that work, in working with law enforcement around the state, one real gap had to do with massage therapy throughout our state. We know, of course, the vast majority of people practicing massage therapy are doing excellent work. And what we found as I was working with those law enforcement officers are that that the lack of regulation sometimes caused significant problems and felt like a real gap. I'll be happy to explain more about that as we continue. I'm looking, my colleague Representative Keeler, I know, has been a leader in this area as well. And I don't want to overstate this particular issue, but I will say that I view this as being part of the progress our state can make against exploitation and trafficking. And it's the reason that initially I had authored this bill for my own motivation, recognizing there are so many other good reasons to advance it as well. And again, happy to talk about that further in the Q&A. I think with that, Mr. Chair, I'd be inclined to move to the testifiers.
Thank you, Representative Pinto. We will move to the testifiers, and then once everybody has testified, we will take questions from members after that. So the first testifier will be Ellie Larson, and the second testifier on deck, Tom Rutman. Ms. Larson, will you state your name for the record and proceed with your testimony, please?
My name is Ellie Larson, and I serve as the Massage Therapy Program Chair at Northwestern Health Sciences University. Thank you, Chair Bierman and members of the committee, for the opportunity to speak today. I have been a licensed massage therapist for 24 years in the state of Iowa, where I built a successful practice that supported my family of 6. For the past 8 years, I've also worked as an educator and program coordinator, and since May, I've brought that experience to Minnesota. I'm here today in strong support of House File 362. Nearly every state in the country recognizes the need for licensure in the massage therapy profession. Minnesota is now one of only 4 that does not. Yet our students, our schools, and our employers operate at the same level of professionalism and rigor as the rest of the country. In 2013, national organizations collaborated on the entry-level analysis project, which established a 625-hour educational baseline for safe and competent practice. This includes anatomy, physiology, pathology, ethics, and supervised clinical work. These are the same requirements that 45 other states already meet or exceed, requirements that Minnesota programs are already aligned with. We are not asking for anything extra. We are simply asking Minnesota to recognize the standards the rest of the nation already shares. The consequences of not moving forward are real. In rural areas without ordinances and no state oversight, untrained individuals can present themselves as massage therapists. Without proper understanding of anatomy, scope of practice, or the effects of tissue manipulation, they can cause serious harm. I have personally seen these injuries and seen people travel to other states, such as Iowa, to seek care from properly trained professionals. These harms are preventable when educational standards are consistent statewide. Meanwhile, our graduates who have invested in high-quality education struggle to find employment that reflects their skill and value. Even for someone like me, with decades of business experience, navigating the patchwork of city-by-city regulations in the metro has been discouraging. Licensure would remove these barriers, support small business growth, and allow therapists to work across city lines with consistency and dignity. Massage therapists play a critical role in today's healthcare system. We provide non-pharmacological pain relief, support aging populations, and help fill gaps in care. Our graduates deserve recognition equal to their peers in the rest of the country, and the public deserves assurance that anyone calling themselves a massage therapist has the education to practice safely and do no harm. For public safety, for professional integrity, and for the future of healthcare in Minnesota, I urge you to support House File 362. Thank you.
Thank you, Ms. Larson. And just so the room knows, we have fewer testifiers on some of the latter bills, so I'm extending the time limit. That was well beyond 2, and I just want everybody to know and be clear about it. So next would be Mr. Tom Rotman, and Kari Borchert, you would be next on deck. Tom, if you would state your name for the record and proceed with your testimony, please.
Thank you, Chairman and committee members. Thank you for the opportunity to testify. My name is Tom Rotman, and I'm a massage therapist in the state of Minnesota. I have my own individual practice, Sage Health and Wellness. I also own Egan Massage Center, and I'm responsible for hiring and onboarding of qualified massage therapists. I'm in strong support for House Bill 362, which establishes statewide licensure for massage therapy in Minnesota. At Sage Health and Wellness, I'm an independent practitioner, and I see between 100 and 200 people per year. At Egan Massage Center, I employ 15 massage therapists and 6 support staff. We see people for pain management, injury recovery, and overall health and well-being and stress reduction. As demand is increasing, I could easily hire 5 to 10 more massage therapists if hiring conditions improve and barriers are reduced. Challenges currently are registration requirements, fees and renewal times, scope expectations, and background checks and standards. Why this bill is so important is it replaces fragmented local systems with single, clear statewide standards. It improves workforce mobility and recruitment. It supports small businesses like mine that rely on skilled healthcare professionals. It increases access to safe, professional massage therapists statewide. This bill does not create barriers. It removes them while strengthening public protection and professional accountability. In closing, House Bill 362 is a practical and necessary step that supports businesses, workers, and the public alike. I urge you to support this Bill 362. Thank you.
Thank you for your testimony, Mr. Rodman. And next would be Ms. Borchert, Dr. Borchert, followed by Barbara York, please.
I'm Carrie Borkhardt, and thank you, Chair Bierman. I'm in Chair Bierman's district. I'm here testifying as a person with experience. In 2024, while staying at Madden's Resort near Brainerd, I got a massage at the Madden Spa. In that massage, the male massage therapist sexually assaulted me. Massage is a very vulnerable situation. I'm laying naked under a blanket. It is common for me to get drowsy and fall asleep. I felt scared during the experience. I froze, just wishing it would be over. Afterwards, I felt very ashamed and embarrassed that I had not somehow stopped it. I'm a child psychiatrist. I should be able to do better. But my reaction was a common one for people who go through this. I know from my professional experience that had I been someone who had a prior history of sexual abuse, this experience could have triggered a relapse of PTSD. Or if I was a teenager or young adult, this could have been much more scarring. I reported it to Madden's, who immediately suspended him. However, there was nothing to prevent him from going to Grandview or some other spa. I filed a police report with Cass County Sheriff's Office. The officer who interviewed me also interviewed the therapist, and I have that report. The therapist admitted to the investigator that he had multiple times sexually touched women during massages. And think about this. He said that about 4 women per week gave signals that they wanted sexual touching, and he wanted to make them happy. Thankfully, he told the investigator that I had not indicated that, but he denied inappropriately touching me. Cass County attorney declined to prosecute my case. The reason was that the therapist denied it, and Cass County has no massage therapy licensing. Thank you.
Thank you for your testimony. Next up, Ms. Barbara York. And Mr. Leo Cashman will be on deck.
I don't believe he's present.
Okay, noted. Thank you.
Mr. Chair,
Please state your name for the record and
My name is-
proceed with your testimony, please.
my name is Barbara York. I have been in practice since 1983. I have been dealing with city and state licensure and ordinance problems, questions since '87. This, again, is the same thing that we have struck down time and again. I am sorry to hear from our victim today that her lawyers did not know about the law that prosecutes these predators. It's under the 609. And they are fined, they are sent to prison, and they come out as a registered sex offender. So regardless of licensing or whatever they are a registered sex offender. The problem is the parties that are bringing this bill did not support that law when we worked with it, the MTMN and the people of Minnesota, practitioners and consumers. They literally wrote a letter to the lawyer asking for their assistance that they would not support this. And this is what's happening. This is called, Minnesota is referred to as not having a regulation. We do, under the 146A Consumer Protection Bill. And then we have the Predator Bill, 609, that this very case would be, and I'd happy to talk to you afterwards about how that gets processed. But you should have known, I'm sorry they did not know about that law. I don't know if it can still be prosecuted, but we'd be glad to help you. The next person that's going to testify after me is a lawyer who has dealt with sex trafficking things. You have in your packet several pieces of information. To start with is the 214, which is the policy and regulation of the state of Minnesota that says that there has to be recognizable and not remote harm to the consumer. These bills have always been brought by people who want to be licensed. They have never been brought by the consumer saying they must be licensed. There's complaints like this. The other side of it is that the Attorney General and the insurance companies that are represented here as well, they should have reports for you. We have asked for these for years. There are no reports of harm from doing massage. There is harm when we are referred to as legitimate massage therapists because it implies that people could get lucky if they find an illegitimate. There's massage therapists and there's sex trafficking. In the realm of sex trafficking, the people who are preferred in sex trafficking would never be able to apply for a license, as Representative Pinto pointed out. He has dealt with sex trafficking with children. That's what it is. They're preteens. They don't even live when they're in sex trafficking. They don't generally live to be 18 and therefore would never be able to qualify for a license. We have protections for the consumers. Michelle Garnett McKenzie of the Advocates for Human Rights, who's now the director with them, had sent a letter saying that these tools for investigation do not accomplish the objectives, but create unintended harm for the victims. A case in Florida was illustrated. Florida has one of the oldest licensing bills in the country. If you just plug in Asian massage, you'll see clearly people who are not doing massage. Anyway, the FBI found that there was an employee of a massage school who had been issuing phony certificates.
Ms. York, I'll ask you to wrap up your testimony, please.
I will. She lodged the Minneapolis ordinance, which is a business license which cities can have that allow people to investigate the people who do not speak languages, and that the tools need to be victim-centered investigations of human trafficking, not investigation parts, but dealing with the victim, whereas what we have is bills that prosecute. I'd like to say in closing that insurance, oh yes, how it affects modalities is simply that when we have a massage license in this country, the words start with touch. And so anybody who is doing a modality outside of massage has to go through massage school in order to get a massage license. And that kills the modalities. It creates a huge barrier for the practitioner. Thank you for your time.
Thank you
I
for your
appreciate it.
testimony.
I'm available for further questions.
Next up, I will second call for Mr. Leo Cashman.
Here he is.
Mr. Cashman, if you would take your seat and introduce yourself for the record and proceed with your testimony. And Mr. Cashman, you have 3 minutes.
Okay, I'll maybe be quicker than that. Leo B. Cashman, I'm a co-founder of Minnesota Natural Health Coalition and Minnesota Natural Health Legal Reform Project. These are nonprofits that were formed back about 26, 27 years ago to deal with the crisis that we had at that time in terms of health freedom and the freedom to practice for massage therapists and other unlicensed practitioners. We worked with the legislature very well in the late 90s. There was a passage of a reform that guaranteed access to these practitioners and supported their right to practice within certain oversight provisions that were put into the bill. And it became Chapter 146A. It's been in effect for 25 years. We think it's been very successful, and we believe that it has demonstrated the safety of the practice of massage therapy and other practices we were assured access to under this statute. So we think that this licensure approach is not necessary, and it perhaps would benefit certain special interests like massage therapy schools, and we can understand that it might enhance their power and effect over this field of practice, but we think it's not justified for the general public, and it does take away the presumption that massage therapists already have the right to practice, and they should have that right. So we support what we already have and what was worked well for 25 years. And so I will stop there, and I think other issues have been covered by Barbara York and others regarding, the oversight that is needed over practitioners doing this type of work. So I will stop there. Thank you very much.
Thank you for your testimony, Mr. Cashman. Next up would be Petra Broken.
Mr. Chairman, how does one get on the schedule to testify?
Today, there will be a time for testifiers from the audience, so you'll have a chance at the end after these. You're very welcome. Ms. Brocken, if you could state your name for the record and proceed with your testimony when you are ready.
Thank you very much. My name is Petra Broken, and I'm an attorney. I live in Minnesota. I think Barbara York was referring to me. I used to be a public defender until I retired a few years ago. I'm also a board member of the Minnesota Natural Health Coalition. So it appears to me that one of the main issues behind this bill is really protecting the public against sex trafficking. And I could probably say that everybody in this room is against sex trafficking and would applaud the wish of you all here to protect the public, which is, of course, your duty and your ability to do that and your duty to do that. That being said, though, what is the legal landscape here, and how does this all fit into the legal landscape, and would licensing actually protect the public? Those seem to me to be the big questions. So, along with your police power to protect the public from something that's dangerous, the people have a constitutional right to have an occupation. The people have a constitutional right to go seek the healing that they wish from the healer that they wish to access. So how do you balance these things? How do we look at that? What other states do isn't relevant here. What's relevant here is how does Minnesota look at this? Other people have mentioned Minnesota Statute 214. What Minnesota Statute 214 and 146A tell you is that Minnesota values the individual rights of the person, the constitutional individual rights, and that is set forth in those laws that this group, this committee needs to look at in terms of what you can do legally. So this tension between the individual rights and your duties are set forth in the Minnesota law already. If you go into 214, and I don't have time here to go through it with you, but I believe that you'll see that nothing in 214, none of those factors are met in terms of licensure. They all weigh towards keeping Minnesota the way it is under 146A and under other laws. So for the first part, the health, safety, and welfare, the literature actually shows that in states where there is licensure, it doesn't solve the issue. For example, Mississippi, that was licensed in 2001, has the biggest per capita of sex trafficking of any state. And so this, unless you have that kind of proof that this will actually work, I'd submit that you should, weigh the individual rights as higher than the licensing. And again, 214 sets that out. And I know that it's already been mentioned that we already have the statutes. When people are injured and there is when there has been, some type of criminal sexual conduct, we have laws on the books. We have a sexual trafficking law. We have prostitution laws. We have sexual abuse laws. These laws are already on the books in criminal law, and they're already set forth as a prohibited act in 146A. So we have two different areas where that this can be shut down.
Ms. Broken, I'll need you to wrap up the testimony.
Okay, thank you. So to wrap up, as a public defender, I worked in juvenile court in delinquency, and I also worked in child protection. And I can tell you that I do not remember ever seeing my clients, who are often trafficked young women, as ever having been in any type of massage practice. We have thousands, potentially, and that doesn't mean that it doesn't exist. I did not see that. That is not what I saw. I saw children not part of massage practices. We have thousands, one person told me between maybe 6,000 and 8,000 massage therapists or Asian body workers in Minnesota who are not licensed, who may have been taught by an elder, who are indigenous and have practices from other countries, who will never fit into what the licensing regulation we have here. And constitutionally, they deserve to be able to practice. Thank you.
Thank you for your testimony. We will now go to a couple testifiers online. First one will be Ms. Nicole Guida, and then followed by Mary Jo Majerus. I will just remind you will have 3 minutes for your testifying. Thank you. And
Thank you.
Nicole, just please introduce yourself for the record and proceed.
Thank you, Chair Bierman and Chair Backer, for hearing my testimony. My name is Nicole Guida. I maintain high standards of integrity as a massage therapist, and so does every therapist I know. Passing HF 362 and HF 2590 would put me out of business. My clients sign a waiver, which includes language that I do not replace medical advice or treatment. That is the only paperwork I have on my clients. I cannot financially afford to take time off from work to travel to complete 625 contact training hours. Not only am I missing income I need to get training I don't need, I would also have to pay with money I don't have to get certification. Massage therapists should not need to be like medical doctors treating symptoms. I do not want that kind of liability on my shoulders. My clients have to pay out of pocket for my services. I do not have the ability to accept a client's insurance as payment like doctors do. Massage therapy is an optional activity. Clients need to research who they allow to touch them. No legislation for massage training is going to stop or deter corrupt actors. Evil will do what evil does, with or without legislating massage training. Predatory behavior under any profession needs to have very harsh penalties, but the majority of massage therapists are touching for healing, not for hurting. We, the people, did not create government to replace our own decision-making. Thank you for hearing my testimony.
Thank you for your testimony, Ms. Gaida, and we will go next to Mary Jo Majerus, please. Ms. Majerus, I believe you need to unmute.
Can you hear me now?
Yes. Now
I'm
we
so
can hear.
sorry.
No worries at all. No worries at all. Please introduce yourself
my name-
and proceed.
Okay. My name is Mary Jo Majerus. I did own Healing Touch Spa in Rochester for almost 4 decades. I just retired at the end of last year. I also still own Massage and Spa, still own and run Massage and Spa Professional Academy, which is licensed by the Minnesota Office of Higher Education. I would like to express my regret to the woman who spoke who was sexually abused by a massage therapist. I would also like to say that in my business, I unfortunately had that happen with one of my therapists who had gone through a background check and met all the requirements of the licensure in the city of Rochester. That person was prosecuted, that person went to trial, and that person was sent to prison. So whatever happened in Cass County, there was something that was missed because 146A does apply to that situation. I understand that there is a hassle for massage therapists in the Twin Cities area who have to get multiple licenses from multiple cities. And I do think there needs to be a resolution for that. However, I am in opposition to this bill, in addition to the fact that 146A does cover any kind of sexual misconduct and allows for prosecution of those practitioners who perpetrate that abuse. I also think that we need to include a pathway for an apprenticeship in massage in our state. Not everyone can afford post-secondary tuition. Not everyone can leave their job or their family to attend a traditional school program. I know firsthand that the apprenticeship model works. In 2023, I launched a massage therapy apprentice program approved by both Minnesota and the U.S. Department of Labor. Our 2-year program included over 1,100 hours of classroom education and nearly 2,000 hours of student clinic. Apprentices finished the program earning $31 an hour. They were well trained and supported throughout, and they were in high demand by both our spa clinics and other employers in the area. Apprentice programs produce skilled work-ready massage therapists. If there's going to be some kind of a bill to organize the different licenses in Minnesota, I think that the apprentice option needs to be included. The demand for massage therapy is projected to grow significantly, yet the number of people entering the profession is declining. We cannot afford a bill that makes it harder to get in. We need legislation that opens pathways, not closes them. I respectfully ask that you not advance this bill in its current form, and I would be happy to work with AMTA representative, and I'm sure that Barbara, who I've worked with many years opposing this every time it comes up, would be willing to work with a system where we could have a registration for massage therapists. But 146A does take care of perpetrators of abuse in our profession. Thank you for your time.
Thank you for your testimony, Ms. Majerus. We are done with the testifiers who had signed up, so now we can move to public testifiers. Any members of the public wishing to testify, if you may proceed to the front table.
Hi, I've talked with you before. Glad to meet you in person.
And please make yourself comfortable, state your name for the record, and proceed with your testimony. You'll have 3 minutes.
Can you hear me?
Yes.
Thank you. I am Barbara Hager. I'm a resident of Minneapolis. I have been a potter all my life. I make an earning as a potter. I made my living as a potter. I'm self-taught. I went to a workshop, but I learned how to do it myself. I also have metastatic cancer for the last 8 years. I'm what my oncologist calls an extraordinary responder. I tell my oncologist it's due to massage therapy. If any of you have had a massage, who's here had a massage? Put your hand down. Put them up high. Don't be ashamed. A lot of people are ashamed. They think touching their body is not a good thing by somebody other than their family. But for me, it relieves stress. And cancer loves stress. So for me, it's a lifesaver. The women primarily who have been my massage therapists for the past 50 years as part of my health regime are sole proprietors. They make an earning the same way that I made an earning. By apprenticeship, many of them learned. Through practice on their family and friends, they learned. And then some people went to school and they learned there as well. But so many of the primarily women practitioners I know don't have the money to go to school. I was fortunate. When I was 50, I was able to go back to school and get an MFA so I could teach, and today have enough money to pay a massage therapist. So what I'm asking you is to think about apprenticeship. Think about how we educate people in the state of Minnesota, what we want from our workforce. I've never been injured by my massage therapists. I've never been sexually propositioned. And to the person who was, I don't see you now, I'm really sorry that happened. It's uncalled for to be assaulted when you are vulnerable. But it could have happened if that person had been licensed, because we see today people with licenses acting in very terrible ways. Thank you.
Thank you for your testimony. All right, we will move to discussion to the bill by members. And first one up would be Representative Hewitt.
Thank you, Mr. Chair, and thank you, Chair Pinto, for this bill. I go back and forth on it, as I was technically trained in my profession as an EMS person. And it really, the license, the certification really shapes on how I behave as to, I have to answer to a higher power. I'm held at a higher responsibility to my patients and to what I do. And so I think that this is a good thing. Now, hearing testimony from others in the room, I also am concerned that we're just creating another thing for upper education here, and I don't really care for that because I think we sometimes can learn a lot OJT. If you ask any police officer, any firefighter, or any EMT, they're going to tell you where they really learn their trade. But it doesn't mean we shouldn't go through a step of licensing. Massage therapy is probably not what it used to be like any other profession. Massage therapy now is looking at getting paid by Medicare, Medicaid. I guess I have to look into that more, but as you do that and you start getting more public funding, you're going to have some sort of certification or license. So I will be voting in favor of this. The one thing, and Chair Pinto, you and I have always had this disagreement, and I'm going to say it again. I'm going to flip this, and I am not discrediting the victim in the room that had a terrible situation happen to her, and that should never happen in any therapeutic situation. But there's a flip to this too, of the therapist actually being attacked by the patient. We see this more and more in healthcare settings where our therapists are either assaulted or in some cases sexually assaulted by their patients. And I think we really need to put the scope high on the patient's responsibility in this role too, of basically saying, you know, that this is where I think a lot of the sex trafficking comes in, and this is that they're assaulting the therapist. So I think that we need to look at that too. I think anybody that is providing care for a patient definitely does not want to be assaulted by their provider. And I know that as a lawyer, as an emergency room physician or as an emergency room nurse, you actually have those protections within the law. I would like to see more of them at this level, and but that's more of a statement than it is a question. Thank you, Chair Pinto, for bringing this.
Representative Van Binsbergen.
Thank you, Mr. Chair. I just want to thank all the people that testified today on behalf of this bill. Representative Pinto, I just have some questions. You know, I live in a rural area, and, you know, I've got concerns about this bill creating less opportunity and taking away people out of this field. All of a sudden, they've got extra burdens, extra costs that they're encountering for this license. And, you know, I think we're going to see less people go into this field. And, you know, I think as we look at what's the cost of doing business in Minnesota already and so many other industries and all the licensures and all the regulations we have in Minnesota, you know, it's just another new license that's being put in place. And so I guess my question is really around cost. What are you seeing this is going to cost for individuals that are going into this field or are in this field? And then, you know, what's the cost to the state of Minnesota?
Representative Pinto.
And thank you so much, Representative Van Binsberg. I hope I'm saying your name correctly. I'm actually going to phone a friend on that, Chair Bierman, if I may.
All right.
Would you state your name for the record again and proceed?
Yes, Chair Bierman. My name is Rachel Romanelli. I am the Government Relations Chair for the American Massage Therapy Association here in Minnesota. I am a licensed massage therapist, Washington State. I have been residing in Minnesota for the last 15 years.
Thank you.
Yes.
Please proceed.
So to address some of the questions here, I think that there are a few that I can come and round back on here. I hear your concern with massage therapists not being able to continue forward and that being a burden to them. 362 really does create a way for massage therapists to be licensed by prior experience. So those people that are currently practicing can continue to do so. Right now in our state, with our two organizations, well, actually there's three, we have just a little under 5,000 massage therapists and body workers that are practicing here. That would come underneath House Floor 362. So in terms of how much this is going to cost a person when they are going into the profession or they're being licensed by the profession, the cost is still pretty low, at least. And it does not, in any other state that we are aware of, mean that that cost goes and is placed on the burden of the massage therapist charging more or having that be something that is not accessible by the public. I hope that answers your question.
Thank you. Representative Van Bensbergen, do you want to follow up?
So, but they will have a yearly license fee, is that correct?
There will be a license fee, and especially like, as we all know and how this works, when this is underneath, will be underneath the Minnesota Department of Health. And so there's an advisory council. And as this goes on, over the years, there will probably be more than 5,000 people. So there will be a cost, but that will also fluctuate slightly as well.
Another question, Representative Bensberg? Go ahead, one more.
Okay, thank you. So you still haven't answered my question. How can we vote on this without really knowing, what's going to be the cost? And what is going to be the cost of the state of Minnesota to implement this? Do we know those numbers?
We need a fiscal note. Yeah. Pardon? Okay. Sorry, our fiscal note was being worked on all the way up until the time of this meeting. So I think it actually is coming in lower than what we had anticipated. I believe that it was a biennial fee was $285 originally. It looks like it's going to come in lower than that.
It looks like there's Mr. Chair, it appears from the website the fiscal note is still in process, and I would assume that before it would actually be a final vote to ways, we would certainly want to make sure that the fiscal note is available for a full decision.
Thank you, Representative Pinto. Yeah, it's still early in session, so a lot of those fiscal notes haven't come in. Thus, some of our bills on the table for today are informational, so that number is still coming. Typically, though, the fees of the licensure through the board would cover the costs. So a lot of that is standardized that way. Representative Gilman.
Thank you, Chair. I got a couple questions here and a couple of comments. So under Section 6, who will be exempt and still be able to practice? We talked a little bit about that, but we've talked about healing touch. There's so many different modalities that are, and I don't see them specifically laid out, but who will be exempt from licensure?
Representative Pinto,
I'm
Ms.
going to
Romano.
direct it as well, Mr. Chair.
Okay. Thank you for the question, Representative Gilman. So really, when we're looking at this, everyone that is in 146A that's covered underneath the current regulation is exempt in this bill. Really, when we talk about 362, we talk about it as that massage therapy and Asian bodywork therapy is actually delineating out of 146A. So we're looking at regulating those professions. We're not looking at doing anything else with 146A. So those professions that still exist underneath that provision still exist and still practice.
Representative Gilman.
So a follow-up with that, thank you, Chair, is what I hear you saying is that folks that practice healing touch to, any type of other modality will not be required to pay any licensure
No.
at all? Okay. All right. that
Another
answers-
question, Representative Gilman?
I have a follow-up.
One more?
Yep.
Thank you.
Yes. So the fiscal note, we talked about just briefly. So the fiscal note isn't even here yet. When I look at on page 13, 12 and 13, when it talks about the commissioner and the application, the action on application starting in section 9, I'm curious, will there be a fiscal note also in regards to what the cost would be to the department?
Representative Pinto.
Would you repeat the question? I'm sorry, I got a little confused.
Will there be a fiscal note, will there be a cost to the department in regards to this bill if it becomes law?
Mr. Chair, I think that's the point of the fiscal note is we'll get the agencies to confirm that. I always hate to sort of make guesses, right? Because I think we've all had the experience of being convinced that an agency will not have a cost, and then they suddenly do. It's very rare we have the opposite circumstance, but occasionally we get lucky enough for that.
Thank you, Representative Pinto, and we'll be getting the fiscal before it's going next to judiciary, I believe.
Okay, so I'll just follow up with one quick story. So I've heard, for and against this proposal. I myself used to do bodywork back in the day. I've been certified in many different modalities. And also, there's been things that have been passed on from generations to generations that I've been able to be a part of. I have seen hundreds and hundreds of, well, I should say hundreds of from little kids to elderly adults and been able to help them. And I was so grateful because I never wanted to be a massage therapist. I'm grateful for folks that do that work, but I never was going to go to school to do that work. What I did go to college for is to become a registered and certified dental assistant. And I'm just curious why we're doing an overarching licensure for this program when, in fact, in so many different places where there's healthcare, we can have certified and registered folks. And again, that keeps costs down, it keeps things affordable for Minnesotans. And I just see this happening, knowing that we full well have protections of the law right now. What this is gonna do is potentially keep people like me that would have wanted to go into doing different things. But what I hear you saying is that those modalities will still be acceptable. I'm just concerned that the folks that have been practicing massage and physical touch, that they will have to then now incur more debt. So I want to
Thank
put that
you.
on the record.
Thank you. On the record. So we have 5 more members who want to speak to the bill, and I would just ask you to focus your questions a little more concisely. We need to get to the next bill. Representative Elkins.
Thank you, Mr. Chair. So I am going to be voting for this bill, and for 2 reasons. One, from the perspective of a patient, I've been referred to experienced, trained massage therapists twice, once for a condition called, sciatica, and the other one for a condition called, thoracic outlet syndrome. It's complicated. And in both cases, I had kind of approached my physical therapist first, and the physical therapist said, "Oh no, for that you need to see a good massage therapist." I saw a good, well-trained massage therapist who was trained on the nerves that are being pinched that were causing the problems I had, and in both cases, a case of massage therapy was successful in relieving the problem that I had. And then the knowledge of the nerve structures that were involved, I can't imagine someone without a full massage therapist training knowing how to do what was going to be required to resolve those problems. Second reason is the reasons that Chair Pinto mentioned at the beginning. The long association, I was a Bloomington City's council member, worked with the Bloomington Police for a long time. Bloomington has a huge hospitality industry, and there's the one aspect of sexual exploitation that has not been mentioned today, and that's the exploitation of massage therapists. What the Bloomington Police were seeing was people being trafficked as massage therapists, being brought in, imported from overseas, and pressed to work in illicit massage parlors within the city, and it was a constant law enforcement problem, for the city. And so the city has always been strongly in favor of this kind of licensing to help control the trafficking of massage workers as well. So thank you.
Representative Nadeau.
Thank you, Mr. Chair, and thank you for bringing this bill, Representative Pinto. I'm an author on this bill. I signed on to this bill because I support. When I looked at this originally, I looked at this is a component of our healthcare system, one of the few that remains unregulated. But today, listening to testimony and listening to some of the concerns, I'm less comfortable today because of that. I don't see. I'm wondering how, and maybe this is my question. explain to me how licensure would eliminate that inappropriate touch, that, and better protect the public. That's my first question. The second question, and one of the reasons that I supported this, was because of the disparate licensure within municipalities. I'm from the urban area like you, and so I also looked at it from that standpoint, making sure that we have a consistent, concise method for people to practice. So if you could address those two things for me, I think I would appreciate that.
Representative Pinto.
Thank you, Mr. Chair, and thank you, Representative Nadeau, for the question. I guess taking the second part, I mean, we've got right now this more than 100 different regimes in different communities having to pay. It's a different licensing fee, different thing, like all that different regulation. This, of course, would provide for uniformity across the state. I think hopefully that's addressing your question on that. Regarding the first piece, my direct expertise relates to concerns about assault and trafficking. So I'm going to turn to Ms. Romanelli in a second for the rest of it. Regarding assault and trafficking, I'll just note the awful experience that we heard about for the testifier at Madden's. My understanding is that when that person left that job at Madden's, but was able to go to to do massage therapy any place else. Because there's no licensing, there's nothing that says that this person can or cannot do that. I understand that there was not a criminal charge brought. The standard for that is very, very high. You have to be able to prove beyond a reasonable doubt. The standard for licensing decisions is appropriately quite a bit less. It's not going to be the same standard as somebody going to prison. In this case, it may well have been, and I suspect it would have been, the licensing authority would find that this person should not be doing massage therapy anymore. Without that, then in fact, that person can be doing that. And I very much agree, Representative Elkins is exactly right, the concerns about people being trafficked, and I've, in what are described as provided massage therapy, and we know that law enforcement, unfortunately, they go in to a site, and how do they know whether the person is in fact educated what's happening? They don't know anything, and we know that this has been a particular concern for international trafficking victims. But again, my expertise in that one area, maybe Ms. Romanelli can help with the rest of your question. I know, very tight on time, Mr. Chair.
Representative Carroll.
Thank you, Chair. I was going to pass, but I think I'll just comment. So my experience is from the city council perspective, and we dealt with a bunch of bad actors. And so when we renew massage licenses and things, and they'd have to go through a background check, and they come up with, bad actions. And so the idea was to regulate at the state level, because if we could shut them down at the city level, they'd go next door to Maple Grove or Golden Valley or whatever. So we wanted to prevent that, and so I'm glad you're bringing this. But that said, there's more complexity to this than I realized. So thank you.
Thank you.
Representative Liebling.
Thank you, Mr. Chair. So, I think it's worth going back to the fundamentals here, and I think it's well known that I oppose this bill, and I've opposed it for many years. When we license professions, we do that for some very good reasons, but one of the effects of that is cutting people out. And we heard some of the testifiers talking about the Constitution. I think this is what they're referring to. You are denying people a right to earn a living in their preferred field. And you're also denying, in the healthcare space, the right of patients to get care from people they might want to. And there are very good reasons often to do that, and that is crystallized in our statute 214. And this has been referred to a few times, so I want to make it explicit what we're talking about here. So statute 214 says, no regulations, and this is for health occupations, no regulations shall be imposed upon any occupation unless required for the safety and well-being of the citizens of the state. And it says the harm must be recognizable and not remote. So what does this mean? To me, it says we don't license occupations in health because of public safety issues that do not have to do with somebody practicing badly. So as a tool for law enforcement, I think there are, maybe it would be convenient for law enforcement in the trafficking space, but this is not a reason in my mind, why we should cut out some people from practicing a profession that they have been able to do and can do safely, and to stop their patients from seeing them. And that is what this legislation is doing. So one of the people who wrote to me in support of this legislation, I wrote back and said, would you mind telling me, because he said he was a student in a massage school and he was supporting legislation. So I said, could you mind telling me how much it's costing you? And he said, for my 500-hour course, it's $13,000. That's a lot of money, especially if you want to practice part-time, which many of these folks do, because it's very physically demanding. So I don't think that for many people, it's 40 hours a week. You're going to be doing it part-time. So what are we doing here? This bill raises the barriers for entry. It may grandfather people who are now practicing, but it raises the barrier for entry. And as one of our testifiers said, there's not even an allowance in the bill for apprenticeship. You have to go to one of these schools and get your 625 hours, and it's expensive. So, you know, right now, to Representative Elkin's point about needing someone for a specialized reason, you know, there's nothing to stop anyone right now from having that training and from telling prospective clients that they have that training. Hey, I'm better trained than many. I've got this degree. You can come to me. I can handle these certain kinds of issues. You can do that right now. So I just do want to say that there are real problems. I mean, having this different kinds of regulation across the state is a problem. We could solve that problem in a different way. And as Representative Gilman said, you know, under 214, you don't have to jump right to licensing. Licensing is the highest level of regulation. There are other ways you could regulate. If there's a real problem, if there's a problem, for example, if clients are having a hard time figuring out who is actually well-trained or who is doing what, we could have some kind of certification system. We could require a background check. We could require fingerprints if that's the issue. We could say that this has to be uniform across the state. There are ways to address the actual issues and problems that are real without cutting out people who are practicing a profession that they want to practice and that their clients want them to practice and that they can do safely. So I just think that, you know, we can achieve our goals without this. This is really, you know, hitting too hard at a problem. It's bootstrapping some problems into a solution that is way too exclusionary. Thanks.
Thank you. We are going to take the last one who had signed up, Representative Keeler, and then we are going to hear from the bill author and close this one out. Apologies, Representative Zalesnikar, but go ahead, Representative Keeler.
Thank you, Chair. I just have a couple questions. You said we're 1 in 5 states that do not have any licensure over massage therapists. Can you tell us what the other states are?
Yes, the other states are, well, obviously us, Wyoming, Kansas, and Vermont.
Representative Keeler.
Thanks, Chair. Follow up, I'm just wondering, like, what are the most recent states who have made licensure adjustments, and have we seen any evidence that there's been this mass reduction in professionals in that field? Or what are some of the best practices we've learned? Obviously, this isn't brand new. This isn't something that like only few states have done. And so do we have any evidence on the impact of business, whether it's in a metro or a rural area, to see what we've learned from other states on the economic impacts here?
Representative Pinto or Ms. Ramanali.
I don't have, well, most states came forward with licensure around the early 2000s. So there's a lot of that. The states that have had the most recent licensing or licensing issues have been going back to Ohio for an amendment to increasing hours, et cetera. We are sorely behind being one of 4 states and the last of 4 states to license massage therapy. So as far as impact to the profession, all licensing has a provision for a license by prior experience, otherwise known as a grandfather clause. So we're not cutting anybody out at all. We're making a very safe and easy pathway for people to come in to this. And licensing, in our view, actually increases access to healthcare because it also increases the availability for it to be part of the medical system as well. You need to have a certification or a license to be credentialed in a hospital and to have access to patient care, or patients to have access to their care. But I can get you more information on fiscal impact, and we can talk about that.
Representative Keeler, anything further? We will go to your closing, Representative Pinto, and any comments you wish based on the.
Yeah,
the
thank you, Mr.
discussion.
Chair. Thanks so much to all the testifiers and to the members of conversation. Particular thanks. Chair Liebling and I have had a number of conversations about this issue through the years. I was looking at that 214A statute that you were referencing. I want to direct members, you've got a very big packet of materials, but if you look towards the back, most of it's about another bill, but right towards the back, it says how untrained individuals can harm clients in massage therapy. As Chair Liebling was speaking, I was thinking that I may be the wrong author for this bill, actually, because my own motivation relates to my background as a sex trafficking prosecutor, but that's not really the reason to do this. If you look at these couple pages talking about the fact is this is a practice that can have a significant impact on patients and on clients, and when such is the case, then we have this sort of regulation referenced that is in licensure. I'll note, as far as I know, no state has reversed. Of the 46 states that have it, there's not any states that have done it one way and that have gone back. It's something that steps that they're taking to protect their populations, and that's true. And I'm looking at the criteria for regulation at 214.001, and would strongly argue that every one of these is in fact satisfied in here. It is a complicated issue, and it's one that most states have pursued and that ours should pursue as well. Thank you for the time.
Thank you, Representative Pinto. I renew the motion that House File 362 as amended be recommended to be referred to the Judiciary, Finance, and Civil Law Committee. All those in favor say aye. Aye. All those opposed?
No.
The motion prevails, and 362 is on its way to Judiciary, Finance, and Civil Law. Next up is House File 2590. Representative Matt Norris, welcome to the committee.
That was our chance.
Please take your seat up front. And I will move that House File 2590 be recommended to be re-referred to the Judiciary and Finance Law Committee.
Did you vote yes or no? Can we do anything still on that? That bill.
And just for the remainder of the hearing here today, I hope we can get through this one in about 15 minutes and then 10 for each of the following. Representative Norris, I understand you have an A1 amendment. Would you like to go direct to explain that amendment, please?
Thank you, Chair Bierman. Yes, I do have an A1 author's amendment. This amendment more or less does three things. One, it makes some technical corrections, updates some dates, things like that. Second, it changes from having members added to the board to the Board of Behavioral Health and Therapy to instead have an advisory council, a clinical art therapist advisory council. That was the result of some conversations with the Council of Health Boards. That they believe that that'll help save some money, probably more fiscally responsible, and so we took that recommendation. And then lastly, this attempts to make some language corrections at the request of the speech pathologists. My understanding, talking today, is that these have been conversations that have primarily been happening at the national level. It sounds like there may still be a little bit of work that needs to be done on that piece, but my understanding is we're laying this bill over, and so we've committed to continuing to work with the speech pathologists to make sure everything gets smoothed over before this bill moves on.
Representative Norris, so you want to lay the bill over here rather than move it? Okay.
Correct.
Just want to make sure. So I will move the adoption of the A1 amendment. Any discussion? All those in favor say aye.
Aye.
All those opposed? Motion prevails, and the amendment is adopted. Rep. Norris, to your bill as amended.
Thank you, Chair Bierman. This bill before you today, House File 2590, would make art therapy a licensed profession in Minnesota. This is something that a number of other states have already done. I think everybody in the room at this point probably understands the importance of mental health and increasing options for people to pursue mental health. We also, at the same time, want to make sure that the mental health care that people are seeking and receiving is quality health care. You know, I'll admit that when the art therapist first came to me, I was a bit of an art therapy skeptic. You know, I kind of was like, well, you know, it's probably, isn't it just, you know, people kind of getting together and, you know, drawing pictures and everything. And over the past couple of years, I have learned, I'll admit, that that there is so much more behind it. There is a lot of science. I've had a chance to attend and participate in multiple sessions where we did some activities that they do in art therapy. I've had a chance to travel the state talking to art therapists, and I think really as you start to learn about this, it becomes clear that there is so much science underpinning all of this, and not only is it something that we want to make sure is broadly available to all Minnesotans, but importantly, when done wrong, it can cause real harm. And that's part of the reason for the licensure today, is we want to avoid those situations where there's a risk for harm. If people who are not properly trained in art therapy are holding themselves out as art therapists or participating in what should be licensed and regulated activities. So this is a bipartisan bill. I want to thank my co-author, Representative Perryman. And we've got a fantastic testifier here, happens to be one of my constituents, and so I'll turn it over to her to share a little bit more.
Thank you, Representative Norris. If you could just introduce yourself for the committee and proceed with your testimony, please.
Sure. Can you hear me?
Very well.
Okay, thank you. I'm getting over a cold, so I apologize for my stuffiness. My name is Brianna Colton, and I am a working art therapist in the state of Minnesota. Chair Bierman and members of the committee, thank you for the opportunity to speak today. I have been a practicing art therapist in Minnesota since 2015. I represent nearly 200 art therapists here in the state. Art therapy as an independent mental health field has existed since the 1960s, believe it or not, in both the United States and abroad. In recent years, it has become more relevant and impactful with the growing study of neuroscience and the therapeutic value of creativity. With that increase in research and application of art making in mental health settings comes the increased need to ensure safe and ethical practice of art therapy. Art therapists receive specialized training in the ways that art materials and art making changes neurobiology, such as accessing memories that are stored as images and not words, expressing feelings that are stored in the body and not easily verbalized, and regulating the nervous system through sensory and kinesthetic activities. With equivalent requirements in education, supervised practice, and an examination to become board certified, we are seeking a state license equivalent to our colleagues in the fields of social work, marriage and family therapy, and clinical counseling. In recent years, the need for an independent state license has become more urgent. First, the current and ongoing mental health crisis continues to create an increased need for accessible, affordable, and varying types of mental health care. Employers are seeking opportunities to expand their services, including the creative arts therapies, and they need credentialed individuals to provide them. And the frequent reliance on health insurance to pay for those services means that art therapists need art therapy services to be reimbursable, to remain an available option for individuals and for families. Additionally, cross-state licensing is becoming increasingly important, and last year Minnesota passed legislation to join the Counseling Compact. While that legislation does not explicitly exclude art therapists, it does address education and related standards for mental health professionals who apply. The American Art Therapy Association is tracking instances where those education standards might be starting to become a barrier for people entering the field. Finally, with the increased prevalence of adult coloring books, art therapy practitioner courses, art life coach courses, there's just a confusion in the marketplace about what art therapy is and is not and who can provide it. This misrepresentation can and does cause harm, and those types of harm, those instances of harm are being collected as well. On behalf of my colleagues, our clients, and the community, I thank you for considering this bill and hope to move it forward.
Thank you, Ms. Colton. Any members of the public wishing to testify on this bill? Seeing none, we'll move to member questions. Representative Liebling.
Thank you, Mr. Chair, and Ms. Colton, thank you for being here. And Representative Norris, I also was an art therapy skeptic when I first learned about this. This has been around for a little while. And what confused me, and I thought I would give Ms. Colton an opportunity in case other people are similarly confused. So, Ms. Colton, right now, art therapists are practicing in Minnesota, right? And they are licensed therapists, am I right?
Yes, most of us are licensed in a different, so I am a clinical counselor, for example. So most of us are licensed either as clinical counselors or marriage and family therapists at this time.
Right, Mr. Chair, if I could. And so, Ms.
Representative Liebling.
Colton, so we're not talking about taking people who are, playing with kids in school or something, doing some other unlicensed thing and then creating a new thing, a new licensing category. We're really kind of carving out art therapy as being something special and different from other kinds of therapy, but it's therapy and you're trained like therapists are trained, correct?
Ms. Colton.
Yes, we often joke about having a master's and a half degree because we get the clinical counseling and marriage and family content, and we also get our therapy content embedded in all of that. So and that is largely because people coming out of grad school were not able to get jobs, and so the schools had to adapt, the programs had to adapt to be able to allow for jobs. It's tricky because then we get into positions and we get into jobs where we are told, I have been told, not to tell people that I do art therapy because it's not a reimbursable service. And so then it dilutes the actual education that we received in favor of.
Representative Liebling.
Yeah, no, that's all. Thanks,
You're
Mr.
good?
Chair.
Thank you.
Thank you.
We don't have any other questions, so closing comments, Representative Norris.
Yeah, thank you, Chair Bierman, and thanks to the members of the committee once again. I really do think that this is a great opportunity for Minnesotans. I'm proud to have art therapists who live in my district. I'm also in my district home to Art Lab RX, which is a really cool space if you want to check it out, or they can also come to you. They've got an art therapy bus that we've taken on the road, and they go around and can do art therapy on the go. So at a time when mental health has never been more critical, especially here in Minnesota, I really think this is one way that we can open up additional avenues for people to seek the health care that they need.
Thank you, Representative Norris. Per your request, we will keep the bill here in committee and lay it over. Thank you very much.
Thank you.
And we will move on to Representative Mahamoud. Next bill on the docket is House File 2760. We'll let you get comfortable, Representative Mahamoud. Representative Mahamoud moves that House File 2760 be laid over for possible inclusion in an omnibus bill. I'll note also that for members, I had planned to offer an A2 amendment, which concerns the FQHC formula. We're going to need a little more time to work that out, so I will not be offering that amendment today. So we'll go straight to you, Representative Mahamoud, to your bill for an opening, and then we'll move to testifiers.
Chairs and members of the committee, thank you for your time. We're bringing forward House File 2760 at an important time for our healthcare system. Recent federal Medicaid cuts under H.R. 1 mean fewer dollars reaching Minnesota, creating more pressures on our clinics, hospitals, and providers. When people lose coverage, their health care doesn't disappear. Patients still need diabetic care, mental health support, and preventative services. What changes is their ability to pay. Uncompensated care rises shifting costs onto providers and clinics. This makes supporting clinics serving our communities even more important. Federally qualified centers and rural health clinics provide primary care, behavioral health, dental services, and preventative care, often as the only option in the area. This bill makes two changes to improve reimbursement so that it's more fair for FQHCs and rural clinics.
One, it'll shorten the look-back period so that DHS will use the cost reports from first and second years prior to rebasing year to calculate reimbursement rates. And second, it adds new scope of change or change of scope criteria for FQHCs so that the federally qualified centers can submit a request to DHS for reimbursement adjustments when the cost of providing services has increased or decreased due to change in type, intensity, duration, or amount of health care services provided in an average visit. And that, I'd like to turn it over.
Thank you, Representative Mahamoud. We'll call up the testifiers. First will be Becky Howard, please, and then Dr. Kelly will be number 2. Welcome to the committee. Please introduce yourself when you're comfortable and state your name and proceed.
Hello, my name is Becky Howard. Hello, Mr. Chair, members of the community. I'm the Senior Director of Administration at Community Health Service, Inc., and we're located in Rochester. We're an FQHC, federally qualified health center located in Rochester, Moorhead, and Wilmer. Federally qualified health centers are primary care safety net clinics that serve communities across the state. We provide access to comprehensive primary and preventative medical, dental, and behavioral health care to patients located in medically underserved areas. So I want to start by thanking the committee for investing in health centers this last session. Thank you so much. This investment allowed CHSI to expand access to dental care, or is allowing us to expand access to dental care in 2 parts of the state through community partnerships. And as we're working on these community partnerships to create new access points, our business is changing. So as you know, FQHCs are reimbursed using a different model than traditional Medicaid. Health centers are reimbursed through the encounter rate-based cost reporting that was mentioned just a few minutes ago. So we have these rates rebased every 2 years, using cost reports, though, from 3 to 4 years prior, and can only have these rates reviewed when there's a change of 2.5% or more than the encounter rate. This has created a lag in reimbursement that's not kept pace with health centers as we change to meet the constant pace of our patients' needs. So the bill before you address these concerns by doing 2 things. First, it adjusts the cost reporting structure from reports 3 to 4 years prior to 1 to 2 years prior. This will allow a more accurate reflection of operational costs rather than using outdated financial data. Second, it adds language that will allow health centers to have their rate reviewed when there's a change in time intensity, duration, or amount of services. This would allow for health centers to more quickly adopt changes like the collaborative care model, expand maternal child health services, or otherwise respond to the complex needs of high acuity patients that we serve. Without this change, health centers lack the flexibility to continue to support the innovative changes that meet the needs of our communities. For example, we're working right now to expand prenatal and obstetrical services as a part of our medical services provided. So our patients face barriers to timely access to prenatal care, including financial constraints, lack of transportation, there's closures of other rural clinics, and limited access, as we know, to specialty providers. So the addition of comprehensive prenatal and obstetrical care will require specialized OB providers, certified nurse midwives, and partnerships with maternal fetal medical specialists to manage both routine and high-risk pregnancies. So the news here is this change will increase patient encounters, require additional exam rooms, ultrasound capabilities, lab services, 24/7 on-call support for obstetric emergencies. So this is a challenge that we are posed and want to meet and would love to take on. However, currently, what it means is pushing those services in, we would wait for 3 or 4 years for these services to be built into our rates through this traditional path of cost reporting and rate rebasing. So this legislation simply change seeks to shorten the time when service levels change to include reimbursement. This bill is about flexibility and the ability for health centers to remain nimble in the face of our changing healthcare landscape. So we want to make sure we shout out an appreciation to DHS for working with us to ensure that any changes to the statute are clear. We want to ensure that we have the right tools available. We know there's still work to be done on the language to achieve that. And we look forward to working with DHS and members of the committee to ensure that outcome.
Thank you. Thank you, Ms. Howard. Next up, Dr. Kelly. Please be seated. State your name and begin your testimony when you are ready.
All right, good afternoon, everyone. My name is Ryan Kelly. I am an internal medicine pediatric physician and work at the Community University Healthcare Center. This is a FQHC in Minneapolis. And I also am providing testimony in support of House File 2760. For those of us with resources like phones, transportation, childcare, educated parents, stuff like that, seeking health care is often, picking up the phone, making a call, checking in at a clinic, seeing the doc, and going to the pharmacy, right? So for a lot of us, a regular clinic fits our needs. But for patients without those resources, often when people do seek health care, all-encompassing medical home is really important. So every day I serve people who don't have that luxury to focus on their health, people who instead are focused on housing or transportation or childcare or food or work, right? And so when people do have the moment to seek care, we need a all-encompassing medical home. I'm going to tell you briefly about a patient of mine. So last week, a patient I've been taking care of a long time named Joe. I've been struggling with housing insecurity, opioid use disorder. He's got diabetes, depression. Last week, he also had an active dental abscess, and his medical insurance wasn't working. So if in my 20-minute visit, I had to handle all that, not only would I probably not be able to help Joe, but I'd probably burn out, right? So luckily, what I was able to do, I touched base with Joe, developed a rapport, made our agenda, did an exam, made sure he had access to his Suboxone and was meeting his substance use disorder goals. But after that, I stepped out and grabbed Anna, our care coordinator. Anna then stepped in, spent some time with Joe, made sure his medical insurance was active, connected him some housing resources. Then Lucas, our pharmacist, comes in. Lucas checked out his glucometer, made sure that, the medical reconciliation was accurate, and also made sure that Joe had a good way of, storing all of his diabetes medications. Finally, Josie, our dietitian, comes in, gives Joe some food resources, and then I circle back at the very end and was able to schedule our follow-up and also do a warm handoff to our dental clinic. While Joe's medical home supported all of his needs, I actually was seeing other people at the same time, helping all of them. To give optimal care, wraparound care is super important. Not only does it help people function, but it keeps them out of the emergency department. In addition, as we just heard, clinics need to be able to quickly and more malleably change their services to support their population. This bill will help that. Finally, I've seen many patients lose their medical insurance, especially with the Medicaid redeterminants post-COVID. And so with every dollar that we lose this ability to support our patients, so every little bit helps. Thank you.
Thank you, Dr. Kelly. Members, any discussion? First public testimony. Anybody else who would like to speak on this bill? Seeing none, we'll move to members. Representative Nadeau.
I get to be first. I love that. Thank you. So I have, and I'm glad that we're laying this over because I have a lot of questions. I think everybody here loves FQHCs and loves to integrate them into our healthcare system. Well, last session, we added a boatload of money to FQHCs and trying to bolster that. I do have a concern on the first part that's being changed from 5.21, where we're going from 3 to 4. And I think everybody here, again, would love to rebase like every minute, if we had the money to do it. But I'm concerned, and you don't have to answer this, it's because you're laying it over and you're gonna keep working on it. I'm concerned that there's gonna be certain FQHCs that aren't gonna have their audits done in that time frame. So just maybe address that issue going forward. And the second part is obviously the biggest change, that looking at starting at 6.11 down to 6.25. It's very vague to me. And so the way it is right now, that increase is mathematical. It's 2.5% or higher in the medical or dental organization encounter rate. One of the things that maybe we should do is have DHS give us a class on how they develop encounter rate. I think we would be more informed and be better able to make decisions. But when you get down into these ORs that we're adding, if the cost to an FQHC providing, when is that cost going to incur, and when would that be part of the timing for that FQHC to ask DHS to kind of rebase? Is it 30 days prior to an expansion? Is it 60 days after a dental bed is added? So I think just honing in on trying to figure out the timing of those things, because otherwise, you would have FQHCs. If I were an FQHC, I'd be asking DHS every month, if I was expanding services or increasing my costs or, expanding to another clinic. So thank you for bringing this bill. Thank you, Mr. Chair.
Thank you, Representative Nadeau. We do not have any other member discussion points, but that was a good one. Thank you. Representative Mahamoud, closing comments on this one, and we can move to the next one.
Yeah, I would just ask for your support in keeping this bill moving forward and whatever that looks like, because it is important that we keep these clinics in service so that we can keep our communities healthy.
Thank you, Representative. I will renew the motion to HF 2760 to be laid over for possible inclusion, but we will have some things to address before we end the term. Thank you. We'll move on to House File 3444. This is also your bill, so we're all set. You may turn your page and proceed. Representative Mahamoud moves that House File 3444 be laid over for possible inclusion in an omnibus bill. And we would ask you to just describe your bill. Thank you, Representative Mahamoud.
Thank you, Chair and members of the committee, for allowing me to present House File 3444. Today we're talking about something very simple. When Minnesotan is ready to begin treatment for opioid use disorder, the system should not make them wait. This bill removes prior authorization and step therapy requirements for FDA-approved medications for opioid use disorder, also known as MOUD. These medications, buprenorphine, methadone, and extended-release naltrexone, are gold standard for care. They reduce cravings, lower overdose risk, and help people stabilize their lives. But too often, when someone makes the decision to seek treatment, sometimes months or years after struggling, they encounter an administrative delay, a form, a review, a wait period, and in the context of opioid use disorder, delays matter. The window when someone is ready for treatment can be short, relapse is high, and in some cases, delay can even mean overdose. Prior authorization is not clinical care, it is paperwork. It does not improve medical decision-making. It creates friction for patients and providers alike, and it disproportionately affects those on public programs. Minnesota already recognizes that certain medications are too critical to delay, including protections for HIV and AIDS drug classes. This bill applies to the same logic here. If coverage exists, treatment should not be blocked by administrative hurdles. 22 other states have taken steps to limit or eliminate prior authorizations for MOUD because the evidence trend is clear. Reducing barriers, improve access to support continuity of care. Members, this is not a partisan issue. It is a public health issue. It is about removing red tape so that people can access evidence treatment when they are ready. So I'll ask for your support and open it up for testifiers.
Thank you, Representative Mahamoud. First up to testify, Dr. Kelly. We'll see him again. And then we have a virtual testifier after Dr. Kelly.
Welcome back.
Please proceed. We know who you are. Thank you very much.
Good to see you all again. I'm going to give you warning. I'm going to talk about some sad things. I'm testifying in support of House File 3444. I mentioned that my name is Ryan Kelly. I'm internal medicine pediatrics. I'm also an addiction medicine doctor. My testimony also is representing, I'm also representing the Minnesota Medical Association. So I've been prescribing medications for opioid use disorder since 2015. Back then, life-saving medications like Suboxone, one of the most common forms of buprenorphine, required a prior authorization. Clinics like mine, we'd have to hire specific people that their only job was to do prior authorizations for Suboxone as fast as possible. But even then, the fastest we could get this medication back then was anywhere between 1 and 3 days. So what that meant is I'd have someone come to clinic in withdrawal, wanting to stop using heroin. I'd send the medicine to the pharmacy, but I have to tell them, hey, hopefully it'll be there within 3 days. Time and time again, we never see this person again. We'd find out days, weeks, sometimes months later that they had overdosed and died. I'm going to fast forward and tell you a little bit about a patient dear to my heart. The first time I met Ray was actually many years ago. Actually, he'd been struggling with homelessness, severe opioid use disorder. I met him in the hospital. He was dealing with the consequences of injecting drugs and had a heart infection. But with the life-saving access to medication like Suboxone, he was actually not only to, become sober, meet his goals, he actually, got housing. He became a pillar in his community. His entire housing complex recognized Ray and his bright smile, which would warm the room, and his cat, Jem. He started working. He was supporting not only his mom, but his sister. Unfortunately, last spring, as what happens with substance use disorders, Ray relapsed. Due to the inherent properties of fentanyl, time and time again, we kept trying to get him on Suboxone. He was motivated, just wouldn't work, and he kept getting sick. Well, finally, I last saw Ray end of September on a Friday. We decided we were going to do prior authorization for Brixadi. He was so excited, and I told him, we're going to have it Tuesday, man. Monday, his mom came to clinic. Sunday afternoon, Ray went to the pet store, got cat food for Jem, took a hit in the car, and didn't wake up. Anything that we can do to get access to these medications that currently exist or future medications for opioid use disorder is going to save lives. I'm available to answer any questions. Thank you.
Thank you for your testimony, Dr. Kelly. Next online would be Jason Urbanchik. Can we do a sound test?
Yes. Can you hear me well?
Sounds great. Please introduce yourself for the record and proceed with your testimony.
Thank you. My name is Jason Urbanchuk. Good afternoon. Thank you, Chair Bierman and Chair Bacher, members of the committee, for hearing my testimony today. My name is Jason Urbanchuk. I'm here as an executive committee member with Impact Minnesota for the Minnesota Coalition for the Homeless, and alongside many other hats I wear in our community. I currently reside in Moorhead, Minnesota, and I'm here today because I've survived something that a lot of people haven't. I survived the wait that the doctor was just talking about. Excuse me. Let me tell you what the wait really means in my world. Wait looks like defeat, means I'm never going to get help. Wait looks like a death sentence disguised as paperwork. Picture this, you wake up one morning in a rundown motel, the same morning you normally wake up and the first thing you do is use heroin. But not today, something inside you shifts. You decide to try, you decide to fight, you drag yourself to a clinic at 5 a.m. to wait in line hoping you get in at 9 a.m. and there's still a spot for you. Shaking from withdrawal, terrified and ashamed. You sit in a room with strangers and confess the darkest parts of your life. You've done the hardest thing a person in active addiction can do. You've asked for help. And the doctor says, yes, I can help you. They write a prescription for a medication that can save your life. For the first time in a long time, you feel a flicker of hope. And then you hear the words that kill the hope. Your insurance company needs more proof. It'll be a few days. Hang in there. Hang in there. When your bones feel like they're breaking from the inside, when your skin feels like it's going to crawl off your body, your brain screaming for relief louder than any rational thought. Every second feels like punishment for trying to live. Most people can't hang in there. They go back to using. It's not because they want to, but because withdrawal is the kind of suffering most people will never understand, nor would you want to. Trust me. This is not a story. This is my life. I was forced to wait twice. And one of those times I didn't make it. I overdosed. I was that close to help and still dying on the floor. If someone hadn't found me, I wouldn't be here speaking to you today. Do you understand what this does to a person? To finally reach out for help and be told to wait? To be ready to live and be pushed back toward death? When somebody is ready for treatment, the window is very tiny. The window for the will to get treatment is even smaller. We can't pretend prior authorization is harmless. It kills people, not in theory, not on paper, in real life and in real time. These outdated processes destroy trust in doctors, in systems, in authority. People don't turn away from treatment because they want to be difficult. They turn away because they've been hurt, dismissed, or abandoned by the very institutions that were supposed to protect them. I've been in recovery for 7 years, 3 months, and 22 days now. That is because the third time, I didn't have to wait. Suboxone has saved my life. It's given me stability, dignity. Hell, it's given me the ability to take control of my life and be the man that I am supposed to be. And at the same time, my heart breaks every time I hear about someone dying in the same gap that almost killed me. Doctors know what their patients need, insurance companies do not, and it is dangerous and frankly irresponsible to let insurance companies override medical judgment in the middle of an overdose crisis. Minnesota has a chance to do something simple and profoundly life-saving. Just end prior authorization for methadone and buprenorphine, let doctors treat, and let patients live. I'm standing here today because someone gave me access to treatment without delay, and I want every Minnesotan to have the same chance, not just the lucky ones. Thank you.
Thank you, Mr. Bonchik. Any members of the public wishing to testify on this? Seeing none, we'll go to discussion on the bill, and I have Representative Keeler.
Thank you, Chair. I hope Jason is still on. Jason is a constituent of mine. And I met Jason back in 2020 when I started this campaign. And I think we all have moments in our life where somebody just says something to you that's so profound. And you know what Jason said about he survived the wait, you just have no idea how many people don't and how that impacts generations to come. I lost my niece because she wanted so bad to get better, but surviving the wait is the hardest part. And I want to thank you for carrying this bill, but more, I really want to thank Jason. Jason made a comment to me early on in my sobriety, in my walk with sobriety, that said getting sober was the best thing he ever did for his mental health. And I think that in a time that we're all doing what's best for our mental health, and we know that this is an act of absolute resilience, that we need to listen to the people who are border to border asking for us to do this. This is actually something that will save lives, and it will save lives every day. This isn't just one and a minimal amount. We are losing our kids to things like this. And so the courage to continue to speak up, and Jason does such a great job. This is also why I just want to highlight the importance of having remote testimony so that we can continue to hear these powerful stories from across the state. And so thank you, Chair. Thank you for carrying this, and thank you, Jason, for your amazing testimony.
Thank you. Representative Bonner.
Thank you, Mr. Chair. More comments than questions, but what we're trying to do here today isn't new. We've been trying to do this for a while, actually. In fact, if I'm not mistaken, the language we're striking here and replacing was, I believe, Representative Kelly Morrison's bill that we passed a couple of years ago. And again, a couple of years, then a little longer passed. And the bill that I passed on prior authorization that went into effect January 1st of this year includes things like chronic conditions. So you only have to do prior authorization one time. And then you don't have to prove that you still need your insulin year after year, even though you can't live without it. But the one thing that was on the top of that bill that we tried to pass was actually this. And we didn't pass it. And does anybody want to know why it failed? Anybody? It failed because it costs too much. But here's two people who came today with the courage to talk about what they've been through. It costs too much. But I have to ask people in this room, what is a life worth? What does that cost? And these are folks who are sitting in a situation in which they cannot wait, in which prior authorization is not useful. It is actually a barrier to people to getting life-saving care. And for that reason, it frustrates me infinitely that I didn't get it passed the first time and that we are still here having this argument. We know that getting this care to individuals saves lives. And yet, we continue to argue about the cost, and we continue to argue about what it's worth to save someone's life. And I just think that maybe, just maybe this time, we'll listen. Thank you.
Members, we are at time, so first off, apologies to the next bill. We will move that forward. Thank you. You have closing comments?
I'll just say thank you guys for your time. Like I said before, people can't wait. This bill will save lives.
All right. Representative Mahamoud renews the motion that House File 3444 be laid over for possible inclusion in an omnibus bill. We will have some work to do on this, the last one, and we'll move them forward together in an omnibus. So with that, thank you for your attentiveness today. Appreciate that. And
Chair,
this,
Chair, I just have one question. I guess I'd move to reconsider House File 362. When I looked around the room, I believe that there were more negatives than positives on that, and I'm just not sure how that works. I am a new legislator, and I just want to learn this. This is a learning experience for me.
sure.
But
I
to
heard,
me, there were more no's than yeas.
thank you, Representative Rapinski. I heard clearly more yeses than nos, but if we want to do a roll call, if you're asking for a roll call, I will reopen that and we'll do a roll call.
Yes, I would.
Yes, okay. So we will do a roll call on 362, House File 362. That is the massage licensure bill. And when we are ready, the chair votes yes.
Chair Bierman,
Yes.
Chair Backer,
No.
Vice Chair Ryer,
Aye.
Vice Chair Nadeau,
No.
Representative Bonner, Representative Bonner, Representative Curl, Representative Dibble,
No.
Representative Elkins, Yes. Representative Franson,
No.
Representative Gilman,
No.
Representative Lee, Representative Curl,
He's saying Carol?
yes.
Aye.
Representative Bonner, Representative Hewitt,
Yes.
Representative Keeler,
Yes.
Representative Knudsen,
No.
Representative Liebling,
No.
Representative Mahamoud,
Yes.
Representative Berryman,
No.
Representative Purcell,
Purcell, aye.
Representative Rubinski,
No.
Representative Schumacher,
Aye.
Representative Van Binsberg,
No.
and then Representative Zelenskar.
No.
Chair, we have 10 ayes and 11 nays.
And the bill does not pass. Representative Rapinski, thank you for that call. And we will have a, next meeting will be on Wednesday under Chair Becker.
Thank you.
Thank you. Meeting adjourned.